Hey guys, we have a new filing in the Owens bankruptcy case that we're going to go over. It just came out a couple hours ago, and the United States Trustee is asking for a dismissal and a bar for refiling for 2 years rather than a conversion for Chapter 7. She's going to talk in these pages about why she made that decision. So we'll go over that. Tiff may be coming in late. She might join us for a little bit. This isn't a super long thing. I think it's like 12 pages. So let's give her a minute, and then it might actually be a little bit longer. She's on her way back from physical therapy. So I see Omar is here. He says, it's Monday. I can't even. I mean, he sounds like Garfield. What's up, man? Hey, Bruce. Hey, Sarah. How's it going, everybody? Clayton's Justice on X. Thank you for the notification of this filing. They were the ones who put it out that I saw. I'm going to put this hat on, or I'm going to be touching my hair the entire time. Hey, Jen. What's up? Michelle. Okay, hi everybody else. I can't say hi to everybody. Anyways, let me pull this up for you. And this is related to the same case as the hearing we listened to. It was either last week or the week before that it took forever and a day for us to get through because it was a long hearing and there was so much to say about what was going on there. Let me pull this up to the point. Hopefully you guys can read that. Hopefully the text is big enough. So we'll see. Guys, if you don't get notifications when I go live on YouTube and you want to get notifications, you can join my Patreon for free. You don't have to pay any money or anything like that, and it'll give you a notification every time I'm going live. I always post it on there. Mods, if you could post a link to the Patreon in the chat, that would be great. All right, let me get started, and then we'll see. Tiff will probably hop in a little while. 5:30 your time. That's really soon. Sorry, I was reading a message. Hopefully she'll hop in a little while. If not, then it'll suck if we miss her, but hopefully she'll be here. So, okay. Says the UST files this supplemental response to the motion to dismiss filed by debtors. And then the judge had initially said no to their motion to dismiss, but now there's a supplemental response to it. They're trying to, get out of this rather than go through with a conversion to Chapter 7, or they were supposed to do some sort of deposition that didn't end up happening, I guess, because they figured out that they were not going to be able to. They were either going to have to convert to Chapter 7 or they were going to have to dismiss. So, all right. Starting Monday with minor disappointment. Why? Okay. Thank you, Sarah. Appreciate that. Okay. Let me hit that. Because whenever I post about something, it shows up there. There we go. I think I got the right message. There we go, yeah. Okay. Debtors filed their voluntary bankruptcy petition under Chapter 11. Okay. They previously filed a voluntary bankruptcy petition in this court under Chapter 13 on August 14th, 2025. So they filed and then they dismissed and then they refiled, presumably to stop the foreclosure of their home. Which was, that's obviously not the proper way to go about a bankruptcy. They seem to not have been honest in their disclosures, as we'll read here. They were just kind of half-assing it seemed, to stop the foreclosure, which now their home is definitely going to be foreclosed upon unless they can come up with a ton of money pretty soon, which I don't know what they would have to do that, but, All right. The Chapter 13 was dismissed on January 26 based on debtors' failure to comply with the recommendations of the Chapter 13 trustee with respect to the debtors' Chapter 13 plan. Yep. Okay. Oh, that's right. I forgot. They didn't do what they were supposed to do. They were asked to, I think they had to submit some tax filings, tax returns, and among other things, and they didn't do it. So hopefully when Tiff's here, she can remind me of what that was. Okay. They filed this case on May 22nd, 2026, less than 4 months after the Chapter 13 was dismissed. On June 8th, the debtors filed their emergency motion to continue the stay, to which the UST objected. The UST incorporates the UST's objection to the motion to continue stay as if fully set forth herein. A final hearing on the debtors' motion to continue to stay was held on July 1st, at which time the court denied the debtors' motion. So they were trying to say that the mortgage holder is doing something wrong. They've done a violation or something. And so they were trying to say, we need to stay. The judge said no to that. They would have to work that out with the mortgage holder, so the lender. And I don't see that happening. I don't think this is going to end well. So On June 24th, debtors filed their motion to dismiss the case. Okay, that was a little over a month ago. The UST filed a limited objection, requesting the case be dismissed with prejudice and a 1-year bar to refiling. At the hearing, the court withheld ruling on the motion to dismiss, and directed the debtors to produce certain documents, including an accounting of certain GoFundMe funds received by the debtors pre-petition. Right. Thereafter, the debtors produced documents and appeared for examination under oath at the meeting of creditors. That's the thing we listened to a couple weeks ago, which was an entire shit show. Let's see. Debtors also amended several schedules and statements of financial affairs. And remember, they amended and submitted those beyond the deadline. And then also Jan did not have her computer in front of her, supposedly, for the hearing, which is why she couldn't answer so many questions, obvious questions that she should have the answer to. All right. The court will consider dismissal at the continued hearing set for August 6th. That's in 3 days. The UST now files a supplemental response to the motion to dismiss, requesting the case be dismissed with prejudice with a 2-year bar to refiling bankruptcy in any federal bankruptcy court. So they can't just go to another court and file in a federal court. So if the judge approves of this, which I assume they will. So, okay. In advance of the August 6th hearing, the question that the UST has evaluated is whether creditors are better served by conversion to Chapter 7 or by dismissal with a 2-year bar to refiling. The UST has concluded that dismissal with a 2-year bar is the superior outcome. The UST's investigation raised serious and unresolved concerns about the accuracy of the debtors' sworn disclosures. Okay, so basically they didn't tell the truth, even though they swore they were telling the truth under oath, penalty of the perjury or whatever. However, in light of the debtor's current financial status, dismissal is preferable to conversion. The UST has reviewed 18 months of statements for 8 Bank of America accounts, and that review establishes that there is no meaningful pool of collectible non-exempt assets for a Chapter 7 trustee to liquidate. Conversion would cause delay for creditors and administrative expense for the estate without the likelihood of any return to unsecured creditors. So they're not going to be able to pay, even if they liquidate everything they have, they're not going to be able to pay these people back with whatever they liquidated, it sounds like. Let's see one more time. Review establishes there's no meaningful pool of collectible non-exempt assets for a Chapter 7 trustee to liquidate. Yeah, okay. Across 3 sets of schedules, the Chapter 13, the original filings in this case, and the amendments filed right before that hearing that we listened to, the debtors have sworn to statements that cannot all be true. That is yeah, that track. Hey, what's up?
Hello.
How's it going?
Good. I am driving, but I'm being careful, and I'm audio only, so nobody freak out.
As long as your hand's free, we're good.
I am.
Okay. So I don't know if you've seen this or not.
Yeah, I have.
You have. Okay. So she's explaining why they're wanting to dismiss with the bar to refiling versus the Chapter 7 conversion. And I just read here, she said there is no meaningful pool of collectible non-exempt assets for Chapter 7 to trustee to liquidate. Do you want to comment on that for me? Because there's some things I just cannot articulate. I barely understand some of this financial stuff.
So what she's saying is, like, they don't even have anything that a bankruptcy trustee could sell off to get enough money to not only pay for that process of collecting and selling stuff off, but also to, like, it would not benefit the creditors, really. Okay, right. And yeah, like they are in over their eyeballs and everything, and they don't have any real collectible assets. Yeah. I think there's some, but I don't disagree with her that there's probably not enough to make the financial aspect worth it. The expense. Right, okay. Yeah.
So what does it cost to, like, get all that together and liquidate it? So they would basically be spending money to get money liquidated, and then it would kind of even out, or how would that work?
Yeah. So have you gotten to the horse part yet? Because she explains it pretty well there, I think.
Not quite. Okay. Almost there.
Yeah. So yeah, basically, because they have to pay, like, the trustee has, their hours that they put into it, plus anybody that they hire to actually recover assets. Okay. And then again, even just making the argument of whether something is exempt or not is going to cost money. So I kind of compare it to like, why isn't Clayton going after Laura again, for his judgment? Right. It's the same concept.
Be spending money on lawyers just to recover nothing. Yeah.
Yep. Okay. So that's it. That's my understanding.
All right. So I just read the part where she says the debtors have sworn to statements that cannot all be true. I'm going to continue here for a little bit. Yeah, I know. Ownership of debtors' residence was sworn at 50%, then 100%, then 50% again. Okay. Unsecured debt was sworn at $511,000 about dollars, then effectively at zero, and then at $729,875. When did that happen? When I lost track at some point when they like flip-flopped on some of their stuff. I guess I didn't even see that when it was at zero, effectively zero.
So like when they filed their Chapter 11, they didn't list anything on their they filed their schedules, but they left them blank basically.
Okay.
So that it made it look like, oh, we don't have any other debt. All they listed was their 2 mortgages. They didn't list any other debt, which is dumb because it would have been very easy to just copy it from their Chapter 13 filing, but they didn't even bother doing that. Okay. So technically, when they filed it with blank, they filed it saying that there's nothing there. There's no debt.
Okay.
That's why she says 0 and then back to 7, whatever.
Yeah. Okay. So that was never going to be accurate. They effectively zero part because we know that they have a ton of debt.
Exactly.
Bruce is rapping, I guess, in the chat. He says, my house is gone. My screen is cut, all because the bats were like the photo of my butt.
Oh my God, Bruce.
Yeah.
I like that.
And Bruce, you're welcome to join us if you're not working. I figure you might be working for another little bit because he's an hour behind me. So.
Oh, yeah.
Okay. The debtors' animals were valued at $1,100 in both prior filings, described as 7 retired horses and a dog, while the recent amendments value the Quartet Farms LLC interest at $62,000 and values a single pony at $60,000. Did they get knee surgery or something? Are they like good as new now? Like what the fuck happened here? How did that happen? How do you figure that? Is that even like which one of these figures is closer to right? I'm assuming the lower number, but
yeah, I think what their problem is that they didn't include Scirocco, and I don't even know if I'm saying it right.
Scirocco. I'm not sure, dude.
Yeah, I don't know how you say it.
I know there's a 91 in there somewhere.
So yes, there is at the end. And I don't even know what that means. But so I think their problem is again that they didn't disclose a lot of things, and then when they filed their corrected amendments in this case, like they just overcorrected and to a point where it's also not believable and concerning.
Okay. So I'm assuming that the 91 at the end of Scirocco, whatever his name is, her name is, I don't know, is like part of a combination, and their other ponies must actually have numbers at the end of their names too, and that is where they hide the money. There's a lock combination. Yeah. You know what I mean? Yeah.
I think it's like when you try to set your password and you have to keep adding a number to it.
Hound Servant says She Rock Co. It's a wind. It's a wine. Is it wind? North Africa or Spanish from memory. I don't know, dude. Their names for horses or something.
It's embedded in my brain as Scirocco, so that's how I'm gonna unfortunately say it.
I prefer Frosted Flakes personally, but
Frosted Flakes?
I don't know if Frosted Flakes is worth $60,000 either.
A Frosted Flake seems to be the only earner in that household, to be honest. Like, it definitely makes more than Laura makes. So.
Well, let me ask you a question that I saw in a chat somewhere. I can't remember which thread it was on because this is starting to make the rounds on social media. I saw somewhere that somebody was saying that their pension is exempt, so that they can't. What does that mean?
Okay, so it could be. Their pension is different than Social Security, okay? So their pension could be exempt. It depends on like what kind it is and all this kind of stuff. But the problem for Ronn and Jan Owens is that they have commingled every single dollar of their money into other funds, including funds for their daughters' accounts. So the second you start moving money around, it becomes collectible. The people collecting still have to make those arguments, but I don't think it'd be a very hard argument to make.
Okay.
Yeah.
Let's see. Where were we here? We went to the $60,000 pony, but a single pony at $60,000. It's crazy. Debtors previously answered no to Schedule G, asking whether any leases were outstanding as of the petition date, but just recently disclosed a 12-month lease of the pony to a third party. Wait, so why did they not write that on there? Because it's obviously income they're getting, right? They're getting paid for the leasing the pony, and they're just gonna see if they can escape that one under the radar or something. Like, what the fuck?
Yeah, no, that's their game. We're not going to tell you about it until you catch us on it.
Imagine doing that, though, when you're already under so much scrutiny, and the judge is like, give me an accounting of your GoFundMe, and then they amend their filings and do more sketchy shit. Like, what are you doing, bro?
I literally don't understand their point.
All right, yeah. Okay. Neither prior filing disclosed business income, yet the SOFA amendment. What is the SOFA amendment?
Statement of Financial Affairs. Short.
Okay.
Yeah.
Yeah.
Initialism.
So they're not itemizing their SOFA. Okay, just checking. Yet the SOFA amendment reports gross business income of $40,785 for 2024, $81,000 for 2025, and $26,000 for 2026. Neither prior filing disclosed GoFundMe income, yet the debtors had received more than $100,000 from GoFundMe donations. The amendments recently filed now disclose the receipt of $131,590 of GoFundMe funds in 2025 alone. And remember, that number still gets bigger because there are recurring donors on there that are getting money taken out of their account and to that GoFundMe every month. So,
Yep.
God, that sucks. All right. Item 13 of the SOFA asks for all gifts over $600 per person within 2 years before the petition date. Twice the debtor stated under oath that there were none, but the recent amendment now discloses $19,608 in gifts to daughter Laura Owens. My God, that is an expensive gift. I mean, they already got her a bunch of ponies, right? So now let's just give her $19,000.
And every expense,
I saw somebody had, they said like there's a certain taxable amount, and that was like just under the taxable amount or something. Is that right?
I think so. I think it's actually well under the taxable amount. I think the distinction is that it's under the indigency amount.
Oh, right. Okay.
Yeah.
So what is it, 20,000 or something?
I think so. I'm not 100%. I think it's $2,000 a month. So I think what's that? 24,000. Yeah.
Yeah, 24. Okay. Yeah.
That's just based off my memory, but I believe it's about that.
That's a lot of money to be giving your kid when you have to pay for your house. But okay.
Right. Well, if you're Ronn and Jan Owens, you don't have to pay for your house because they're going to write letters about all the wrongdoings. So.
Right. Okay. The mortgage company is actually they made an error. So.
Yeah.
All right. Let me run through these real quick. Buffy Lynn, thank you for the 200 joules. Appreciate that. Michelle, thank you for the 30 joules. Let's see. Sue Hennon. Hopefully I said that right. Hennon Flynn, thank you for the 6 joules. Danny Extreme, thank you for the 2 joules. Redondo Beach, thank you for being a member for 13 months. It says it's unhealthy how much this entertains me.
Same.
Yeah, well, I mean, look, I'm sitting here talking to my computer screen about it, so I'm not exactly having a normal reaction either. Susan Anstead, thank you for the 200 joules. Appreciate that. Hopefully I said your names right. Appreciate that. Okay, now let's keep moving through here. I guess Bruce has stopped rapping, I assume.
Oh, bummer.
Let me see if he had any more bars up here that I missed. I need to know. Because the first one was good.
That was a good beat, man. Or a good line.
Our credit cards are frozen, but Dad, I need some new shoes, and that's why I've got the bankruptcy blues. Okay.
Oh my God.
My credit score is lower than my felony counts, and the temperature in Phoenix is more than all my bank accounts. I don't know if he's making this up or if he's using AI, dude.
It's beautiful either way.
My dad is mad and only Rich has the news. That's why I've got the bankruptcy blues for more bankruptcy blues. Yeah.
Oh, I dig this. Somebody needs to make it a song.
I think that would be a Megan Fox project, unless Bruce wants to record it himself.
Right.
Oh my gosh. Okay. All right. So we're into the $19,000 in gifts. Let's see. Previously, debtors swore twice that they had made no payments on a debt owed to anyone who was an insider within 1 year before the petition date, but the recent amendment now discloses $21,056 paid on behalf of debtor's daughter, Sarah Owens Navarro, in May 2025, March 2026, and May 2026. Okay. Paid on behalf? What does that mean?
Yeah, like, so what they said in that, I think it was in their SOFA, that that they paid Sarah that $21,000, and it was like 3 different payments, and that because they were paying her back for, I don't know, she apparently, their excuse is that she paid some mortgage payments for them.
She's on the mortgage, yes? Isn't she
I know.
supposed to pay mortgage payments?
Right. And so, like, because she's a borrower, I think they're trying to say that I don't think they disclosed it the right way. Let's just put it that way. It's an insider payment, and it doesn't make sense. So it doesn't make sense the way they disclosed it.
An insider payment, what does that mean in general?
An insider is a family member or a business member that you have paid money to.
But paying money to their own LLCs, that would be a no-no. Is that what we're saying?
I mean, they would. Yeah, it's without it making money. Yeah, it's concerning.
Gotcha.
Yeah.
All right. Let's see. Until the recent amendments, debtor Naylor's membership and manager interest in Good Luck Shop LLC went undisclosed in both cases, even after the Arizona Department of Revenue raised it in the Chapter 13. Manager interest in Good Luck Shop. Do you think Good Luck Shop has made any money?
I think it has.
What do they sell on there other than like?
Somehow. Well, there's like, okay, if you know nothing and you really are into the equestrian world and you know nothing about Laura Owens, then like it's got that kind of theme to it, right? I mean, it's stuff we find hilarious because we know who designs it or whatever, but I mean, crappy stuff sells, man, sometimes, right? And I think that's just where it probably is making something. I don't know if they're doing like show circuits where they're like setting up a table. I don't know. I just think it's possible. If nothing else, it's got money running through it.
I didn't even think about that, setting up a table at the events. Yeah. Obviously, they're still going to them. So
yeah, and I don't even think you have to have stock on hand to do that. Like you can just have some samples, and people can order, and you can have barcodes scanned, right? Like, so yeah.
Fake Laura Owens, thank you for the $5. Yippee, we're not broke and poor anymore. No more bankruptcy. Daddy, take me.
What? Going back real quick to the Good Luck Shop stuff. So the state of Arizona filed a claim against them and an objection against them in their Chapter 13 regarding the Good Luck Shop and their personal income taxes. The fact that they've done nothing with the state to say, no, we don't actually make money on that. Here's our proof. Here's our filings that we don't make any money on that. Good Luck Shop is kind of, to me, proving that they do make money on the Good Luck Shop.
Okay. Yeah. Texas Proud 8822, thank you so much for the $50. Wow. Never hide things in your sofa. That's so nice of you. I will not hide that $50 that you just gave me in my sofa.
Right.
I will hide it in Tiff's sofa. Thank you.
My sofa would appreciate it.
Yeah, thank you so much. That's really generous. All right, let's see. The recent amendments also disclosed for the first time $7,000 in cashier's checks, Charles Schwab accounts, and $10,250 of antique furniture, while a monthly in-home care expense of $2,400 and a monthly horse insurance expense of $425 each appeared in one filing and vanished from the others. With the in-home care expense, aren't they're his full-time carers per their court documents and such?
Yeah. So it's weird that it appears and then it goes away. And
were they paying her the $2,400? Is that why?
Right. And was it over the amount of indigency and they had to change it? That's what I think.
That would be right. Yeah, that would be right about, right? At $2,400. If it was $2,000 per month, it would be $24,000, right? And then $2,400 will put them over.
Yep.
Okay. Well, wow.
That's what I thought. Like they always have to correct something that they find out later. It's like the twin timeline, right? Like it's either July, September, October, November. We don't know because we had to adjust it for all the things we said that were wrong.
The HCG level of their bank account is very high.
It's inflated.
Maybe that's why Laura had all those payments to MedSpa or whatever, injecting the HCG into the bank accounts. I don't know. All right, let's see. Statements of this character, if proven to have been made knowingly and fraudulently, would support an action to deny discharge. The UST does not abandon that view, but pursuing that remedy would not benefit the creditors that the UST is bound to protect. So it sounds like in this context, like this kind of civil context, there's really no benefit to that.
Right. And she really does a good job of explaining it in this part, in my opinion.
Do you think that, before I get to the next section, do you think that they would bring criminal charges for something like this? Or do you think no?
Oh, I think it's possible. I'm not saying they won't get like some sort of special treatment because they're stupid age, but I like in terms of sentencing if they got whatever. But I do think like this is stuff that the bankruptcy court, if you look at the past bankruptcy, different filings of different cases, it's absolutely something that they would likely investigate, especially with the way this is all worded. And also, I just recently found out, and I don't know why it didn't occur to me before, that Judge Wansley is the chief judge of the Arizona Bankruptcy Court. So, yeah, she handles some pretty high-profile cases. She's not new to that. It'll be interesting.
Okay. And I'm assuming the judge will probably allow this, right? The dismissal with the two. I mean, I guess she could technically not, but she probably will, right?
I feel like she might because, again, I think these arguments are not bad arguments to make. And it doesn't stop Ron and Jan from having consequences. Like, this is not Laura's dismissal filing. This is different.
Okay. Yeah, okay.
I'm going to mute myself for 1 second while I go in the house.
Yeah, no problem. Okay. Get some water real quick. All right. The UST does not abandon that view. We went there. Okay, so conversion would yield no distribution. Code section 1112B1 directs the court on a finding of cause to convert or dismiss whichever is in the best interest of creditors and the estate. Okay. Conversion satisfies that standard only if a trustee would have something to administer. Here, a trustee would not. The debtor's residence is secured by liens exceeding $1.9 million against a value the debtors themselves placed between $1.5 million and $1.57 million. Basically, with a first position arrearage above $191,000 that it continues to accrue. There is no equity, and a trustee would likely abandon the residence under Code Section 554A. That is something Tiff is going to have to explain to us because you start talking about things like arrearages, and I'm like, what do you mean? Did I miss anything super important? Should I start from the beginning? That's up to you. You can always go back, I love when Lauren is in the devil works fast, but Lauren works faster mode. Yeah. All right. Well, I can move on a little bit, and we'll come back and ask Tiff when she's off of mute. Okay. Let's see. There is no equity, and a trustee would likely abandon the residence. The animals present no value for creditors for a different reason. Whatever the pony is worth, and the $60,000 figure is the debtor's own estimate, the estate would have to take custody of a living animal and expend estate funds on shelter, food, and maintenance. Okay. Yeah. I mean, I don't think anybody really wants to do that. The debtor's records are, cool. Okay. So before I move on, this sentence right here, I'm going to need your help with. It says, the debtor's residence is secured by liens exceeding $1.9 million against the value they place between $1.5 million and $1.57 million, with the first position arrearage above $191,000 that continues to accrue. What the hell does that mean?
So their house is underwater. That's like the short version of that. Their house is underwater, and like they're behind on almost $200,000 on mortgage payments on the first mortgage alone. So like they owe extra interest and stuff that beyond what the original loan was for. So it's underwater. It's not worth what they owe. So the creditors are taking a loss on that regardless.
Okay. And then they're talking again about the animals, like if they took a custody of the animal, they would have to pay for estate funds on shelter, food, and maintenance. The debtor's records reflect that those costs include boarding charges, feed and supply purchases, veterinary services, and association fees, aggregating $38,499 in horse and farm expense over 18 months. A trustee would need to fund boarding, feed, veterinary care, insurance, and transport from an estate with no cash, would need a specialized broker to reach a narrow market, and would do so while the animal remains subject to a 12-month lease. Oh, yeah, I forgot about that.
Yeah.
The 7 remaining horses are described in every filing as retired, which is to say they have no market and cost money every day. Custody and sale expenses payable ahead of unsecured creditors under Code Section 503B would likely meet or exceed any proceeds realized by the Chapter 7 trustee, who must close the estate as expeditiously as is compatible with the best interests of parties in interest. What?
Like, there is no monies. There's no value. There's no, like, it's going to cost me more to basically, like, if you have a car that's sitting in your driveway on blocks, right? But you have a loan on it, the collection company is going to make the assessment at some point where it's like, is it going to cost us more to get this car out of there than we're ever going to make on it?
Yeah.
And the answer is yes.
Okay, got it. All right, let's see. There are no other apparent non-exempt assets for a Chapter 7 trustee to administer. The amended schedules disclose Schwab holdings of $831.84. That's it? Oh my God. And 84 cents. And retirement accounts of $172 and $102 that are excluded or exempt. And income consisting of exempt Social Security and pension payments. Okay. Remaining personal property is largely exempt under Arizona law and worth little net of the costs of collection and sale, and household goods held in storage secure roughly $26,000 in unpaid charges. Jesus.
Yeah.
That's bad.
Yes, it is.
Oh my God. I can't imagine being that, like, what kind of, you should be that wealthy, but you have $102 in one of your retirement accounts. Like, what are you doing?
No, for real. And this is the weirdest part. Like, they never disclosed this before. So was it more and it dwindled, or did you just, like, it's just pathetic is what it is. That's all.
I don't even know, like, how do you let yourself get to that point? I mean, I guess if you're, like, scrambling not to let people know your family's been engaging in criminal activity for the better part of a decade. I mean,
right.
It's not going very well right now, but so before we move on here, what happens now if they get this dismissal and so they can't refile for another 2 years and they have all these debts? So they just get sued by a bunch of banks, and what happens?
So they will get sued by the creditors that think it's worth pursuing. Okay. Some won't. Some debts will get bought out by collection companies who will then sue because it's cheap for them to do that. Then they'll have to go through the same thing that we saw what Clayton started to do, which was the debtor's exam. Yeah. It's not called that, but what was it called? Crap. But the thing that Woodnick filed.
Yeah, I know what you're talking about.
The thing that Woodnick filed. Anyway, so they would do that, and the Owens would have to come in and prove, if their creditors made an argument that their income was exempt, Ron and Jan would have to prove that it's exempt.
Right.
Sorry, if the creditor made the argument that it's not, they'd have to prove, they'd have to say, and there's like a fine line. It's really sad, actually. I watched a case once where this lady who was just on SSI, and which is really just $900 a month.
Yeah,
but she let it go into her savings account that had other money in it, and it became non-exempt when she did that. Which is sad, right? Like, the second it hits your bank account and starts moving around, that's a problem for you. Yeah,
that sucks, man. Clayton's Justice on X says, to think Ron made almost $1 million a year all those years. Yeah, that's fucking crazy.
Yeah, it is crazy.
My God. All right. I think we read that. Remaining personal property is largely exempt and worth little. Okay, the household gets. Yeah, okay. The insider transfers described above are the only theoretically available assets as avoidable transactions, but realizing on them would require adversary proceedings under Code Sections 547, 548, funded by an estate with no unencumbered cash. Right. Okay. Moreover, a Chapter 7 trustee may eventually determine that the transferees are uncollectible. The transferees are uncollectible. What does that mean?
Meaning, so we're talking about Laura and Sarah.
Right. Yeah.
We know Laura is because she
You can't get
broke,
money.
right?
Yeah.
Right. But I'm assuming that that the trustee doesn't, the US trustee, Jennifer Giamo, doesn't know whether or not Sarah is.
Right.
So that's why she says it that way. Who knows, right? Like we might go through all this effort and find out that Sarah's not even collectible either.
I mean, this has been going through their finances for the last, what was it, 18 months? I wonder how much, anticipating that this was going to happen, especially over the last 2 years, I wonder how much money they transferred to Sarah without anyone knowing.
I don't know. That's a good question. And I definitely think it's more than $21,000.
I mean, she's probably got a savings account that she uses to pay, that they gave her to pay for Laura or something. That's what I think. I mean, that's just my speculation, but that's what I think.
But it is my opinion as well. I do think that it is where it becomes a problem for them, going forward, even with a dismissal, it's a problem.
Okay. All right. Collection from Laura Owens is already called into question by the fact that Laura Owens recently filed her own Chapter 7 filing in this court, which was ultimately dismissed. Yeah. Okay.
Yeah.
All right. Here's the section about the GoFundMe. It says the GoFundMe funds are beyond recovery and any remedy lies outside bankruptcy. The UST has particular concern about the GoFundMe proceeds. The debtors received approximately $132,480 in GoFundMe payouts into a single account, approximately $109,290 of it in January 2025. That's still a good chunk after January, like over $20,000. So it's not like they stopped making money, but yeah. The campaign solicited the public by referencing to debtor Owens' Parkinson's disease, history of cancer, and cardiac condition, and included the representation that his medical struggles had taken a toll, both physically and financially. Over the 18 months reviewed, healthcare and pharmacy disbursements from all 8 accounts totaled $17,209, roughly 2.7% of net spending. Jesus. While discretionary spending totaled $191,192. Okay. In the period during which the funds were deposited, $118,898 was dispersed, including $61,654.75 of mortgage payments. Okay. Thousands of dollars of consumer credit card payments, $44,375 in capital contributions to the debtors' limited liability companies, transfers to their adult daughters, retail and online shopping, food delivery exceeding $1,200 per month, restaurants, subscriptions, and travel. What are you doing?
I don't know. It's insane.
$1,200 per month on food delivery is insane.
It really is. I want to pay attention really quickly here. 61,654. Hold on a minute. 654 divided
TX Packet says, "Holy crap, DoorDash!" Yeah, right. I hope they're tipping good.
I doubt it.
I doubt it too.
It's like no. So that's about 4 months of mortgage payments. If we don't split it up and try to overanalyze it, right? That's just 4 months of both mortgages being paid. So that tells me that they were behind because we know they stopped paying the first mortgage in February of 2025. Okay. So that means that they had been delinquent for November, December, January, and February. These people within 6 months of taking out that loan started being delinquent on it. And then just stop paying.
Wow. Okay.
Yes.
This is I genuinely don't understand how you get this far into the hole. I just don't. I don't understand it. Because at some point, don't people just start denying you? So I'm just kind of how did they get this far?
It's crazy because the system really does reward this. And I'm positive, because I'm sure it's Laura and Jan running the house. I'm positive that they're both very good at the sob stories, right?
Right.
I mean, but we did see the desperation towards the end, those payday loans Jan was taking out with the 98% interest. That's where they started to really feel the impact of what they were doing.
Do you think she offered the people she was talking to and asking for loans, do you think she offered them chocolate?
I'm sure of it.
I want to buy all your chocolate. Do you know the episode of SpongeBob?
No. Where Patrick accuses SpongeBob of eating his chocolate?
No, they have to sell
Oh.
chocolate bars, and that always makes me think of Jan. Always makes me think of that. They have to sell chocolate bars, and this like really creepy person that they think is going to try to kill them or something follows them. He's like, "No, I just want to buy all your chocolate."
Okay, I have to watch that because I don't remember that.
Maybe she should sell all the chocolate bars she keeps for the police officers, and then they'll be caught up on their mortgage. Okay.
It's an option.
Totally. Those facts raise a serious question whether donors received what they were promised, but it is not a question the UST can answer here. The remedy available to the UST is an action under Code Section 727 to deny a discharge. That section protects the integrity of the bankruptcy process and preserves creditors' claims. It compensates no one. A judgment denying discharge would return not a single dollar to a donor, would create no fund, and would not adjudicate whether the representations on a fundraising page were true. The donors in GoFundMe Incorporated are the parties withstanding to pursue whatever legal remedies exist as to the solicitation and application of donated funds in a forum outside of bankruptcy. So what, like GoFundMe could sue or something, or GoFundMe could make a report, or the people who donated could
I think this is a very important paragraph entirely because it's basically saying, I mean, what's the trustee's office going to do to get the GoFundMe money back? Really nothing. It's more civil and possible criminal investigation that would require that, GoFundMe donors could maybe get a judgment.
Mm-hmm. I don't think they would ever get their money back, though.
Right. No, I don't disagree.
There would be more people wasting money on lawyers to get nothing in return. So it would just be like a fuck you at that point.
But I do think that the donors definitely have some sort of possible claim against GoFundMe itself, because as we know, this has been reported. This has been reported since the day we knew about it, right?
Okay. Yeah.
So GoFundMe can't claim that they didn't know.
Yeah.
Or weren't told that this was a problem.
Fair enough.
In my opinion, allegedly.
Yeah. Okay. Well, because I know some people donated like crazy amounts of money. Like somebody donated thousands of dollars, I think.
Yes.
At least one person did. I remember that. And I'm wondering if that person will ever see any of this and think, wow, why did I do that? You know what I mean?
Yeah. I think that the news organizations that really played on the heartstrings when they wrote articles about this have some splaining to do to these donors.
I noticed they've been very quiet.
Right. And I'm not sure that'll be the case for very long, but we'll see.
All right. Yeah. Okay, let's see. Moreover, based on the UST's review of recent bank records, the GoFundMe funds have been fully expended and the accounts carry nominal balances. Therefore, recovery of any funds for the benefit of creditors by a Chapter 7 trustee would require multiple preference actions by an estate that lacks unencumbered assets to fund such lawsuits.
Right. It's going to cost too much to collect.
Mm-hmm. The best interests of creditors in the estate favor dismissal. If the case is converted, creditors will be relegated to waiting to pursue their rights while likely standing to receive nothing from a Chapter 7 liquidation. A Chapter 7 trustee would be appointed, a new meeting of creditors convened. We need to go through that again. The estate would remain open through investigation and abandonment. If the UST filed a complaint objecting to discharge, the deadline would run 60 days after the first date set for the meeting of creditors under Federal Rule of Bankruptcy Procedure 4004. Okay. A contested code section 727 action would then require discovery, depositions, motion practice, and trial. At least a year would pass between conversion and judgment. A lot can change in a year, as this family knows. So that's not good. Yeah.
Right.
Moreover, there is no guarantee that the UST would prevail under Code Section 727. In response to a Code Section 727 action, the debtors would likely attribute false statements to prior counsel and to debtor Owens' documented illness, and would likely argue that the amendments evidence an intent to correct rather than conceal. I mean, they would say that, yeah.
I think she's got their number. I'll tell you that.
Right. The UST believes those defenses would fail, but cannot represent that success is assured. And in any event, success would still yield no distribution to creditors. So they probably wouldn't get away with it, but there would still be no benefit to the creditors to proceed with this action, I guess.
We'd end up in the same spot we are now, only more money would have been spent to get there.
And more embarrassment. But
that part I like.
A Code Section 727 judgment would leave creditors holding exactly what dismissal gives them now, i.e. claims enforceable under state law only a year later. Right, okay. Under dismissal, creditors act immediately. The secured lender may notice and complete its trustee's sale. What does that mean?
The foreclosure.
Okay.
They technically still can right now, but she's arguing her point. I get it.
Okay, got it. Unsecured creditors may file or resume state court actions, including the 2 pending actions by JP Morgan Chase Bank, NA, to reduce claims to judgment, record judgment liens, and garnish non-exempt assets. Okay. Because they already filed the lawsuit, right? Did they dismiss their lawsuit, or is it still just suspended?
I think they dismissed it. I know they dismissed the first one. They have to, like, they can't pause it. So they'll just dismiss it. It'll get dismissed without prejudice, and they can refile it later. Like, it's fine.
Okay.
Yeah.
No trustee stands between them and their remedies. The 2-year bar assures that those remedies cannot be interrupted again by a third bankruptcy petition filed on the eve of the sale. So I'm sure they would have tried that, right?
100%.
But I mean, the thing is, they're abusing the system already to stop the foreclosure on their home, and so like they don't want to let them do this over and over and over again.
Or should I say 98.9% like that APR on that payday loan?
Wait, what is it? 98.9%?
It was the APR on the 2 payday loans she took out last year.
How the fuck do you agree to pay 98% APR?
Because you're Jan Owens, baby. I think those loans right there, that is proof of fraud. But that's just my opinion, allegedly.
That's insane.
Yeah, because she took one of them in April of 2025, right before they filed for foreclosure. Tell me that's not odd.
Good Lord.
Yeah, it was only $6,000, but it was, I think over time it would have been $15,000.
What the hell? Oh my God.
It's wild.
Oh.
And
hey,
you know what? Some people have to do that. I get it. Like I said this. Sick dog, you need to save their life. I totally get it. Yeah. But like that's not what we're dealing with here.
No. They got 7 ponies and how many dogs? I don't know, but
right.
They're not what they were using that money for.
They're not paying to take care of them, no.
No. Hey, Mods, can one of you put a link to Tiff's channel in the chat before I forget? Appreciate that.
Thank you. I'm trying to eat and talk and all that stuff. Thank you.
Let's see. To your bars. The comparison is therefore between a certain and immediate benefit to every creditor and a contingent one available to no one for at least a year that would cost the estate money to pursue and would distribute nothing even if it succeeded. Creditors are better served by remedies they may exercise today than by the prospect of a judgment that is neither assured nor remunerative. What does that word mean? Remunerative. I've never seen that before.
Remunerative.
Like,
I know it, but I can't. Assured nor remunerative. Okay, well, we're gonna have to Google machine.
Paying well, profitable. Okay, got it.
Okay,
I've never heard that word in my life.
Could have said. I guess it's similar to lucrative. Then whatever. Okay.
Yeah. Why not just use that word? Go on.
Right. I'm just saying.
Cause exists to dismiss for bad faith, which also supports the 2-year bar. This is probably the best one.
This is the guts. This is the good stuff. Yes.
Right. Yeah. Cause exists independent of the debtor's own request for dismissal, and that same cause supports the 2-year bar to refiling. Code Section 349A provides that the dismissal of a case does not prejudice the debtor with regard to his subsequent filing unless the court for cause orders otherwise. The phrase, unless the court for cause orders otherwise, authorizes the bankruptcy court to dismiss the case with prejudice. Bad faith is a cause for dismissal with prejudice. I don't know if they did this in bad faith. I don't know. Yeah.
I mean, she wanted to be transparent. We know that. But she said it a lot. I
imagine that Jan, if she were confronted with this by the judge, would be like, no, I don't know what you're talking about. I go to church every Sunday. That's where I left my computer during the last hearing.
Right. It was in the confessional. Oh, wait, no, it wasn't there.
No, not there. Definitely not there. All right. The UST addressed each of the factors required to find bad faith in her stay objection. Those same factors constitute cause for dismissal with prejudice. Specifically, 1, the debtors made numerous misrepresentations in their pleadings in this case and in the Chapter 13. 2, the history of the debtors' filings and prior dismissal show a complete disregard of their basic obligations as bankruptcy debtors, including failing to file and produce tax returns and failing to cure substantial planned payment arrearages. 3, the sole purpose of this bankruptcy filing was to halt an imminent sale. And 4, the debtors demonstrated egregious behavior, including failing to appear at a scheduled initial debtor interview in this case, and failing to produce to the UST standard documents required of all Chapter 11 debtors until ordered by the court to do so. And not even then, they were super late on that.
Exactly.
So, yeah. In the recent case of Henry Corbin, let's see, the court confirmed that bankruptcy court has authority to dismiss a bad faith case with prejudice. And considering whether dismissal with prejudice is permissible, the Corbin court cited the Second Circuit Court of Appeals decision. Okay. We can skim over that, which held that the bankruptcy code authorizes bankruptcy courts to dismiss bankruptcies filed in bad faith with prejudice, that is, with a bar on future filings beyond the 180-day period contemplated by Code section 109G. Okay. I'm actually going to skim the summary of this case because I don't need to go through that. All right. A dismissal with prejudice cannot be avoided simply because the debtors themselves seek voluntary dismissal. The Corbin court addressed and rejected precisely that argument, holding that while the debtor does have an unfettered right to dismiss her bankruptcy, she does not have the right to evade the consequences of her bad faith filing. In this case, a 2-year bar to refiling is reasonable and proportionate. The debtors have filed 2 petitions in 10 months. Each filing interrupted a creditor remedy, and the second filing followed dismissal based on deficiencies that the debtors made no effort to cure. So they didn't do anything to fix the problems.
That sounds familiar.
A shorter bar would expire before a trustee's sale could realistically be completed and would invite the third filing that Code Section 362C3 was enacted to discourage. 2 years is long enough for creditors to complete their remedies without interruption, and not so long as to foreclose relief should a genuine need later arise. So basically, they can't stop anybody from trying to collect improperly.
Yeah. And I think like the point is like, if people haven't been able to successfully do that in that 2-year period, if they file again, then okay, then this is, maybe they really need it this time.
Yeah. I don't know if they'll, Jan might be in prison by that time. I'm not positive. We'll see.
One can hope.
Ron will hopefully, if that happens, hopefully have full-time care in like an appropriate setting. You know what I mean? But like, I don't see Ron going to prison.
I hope it's a bunch of broads that have to take care of Ron.
What? Wait, explain the thought process there. What do you mean?
Oh, so Kimberly on Reddit did this article about I think it was Kimberly, somebody on Reddit, sorry, did this article about Ron's previous marriage and possibly plural. And one of his engagements in a news article, he said that the unaliving rate of single broads has already tripled or something like stupid like that. Yeah, it's like the grossest comment. And it's very Ron. And it's just like, okay, Ron, whatever. Like, you're so gross. Nobody's...
Oh, my God. Okay.
Yeah.
Okay. All right.
Yeah, so I hope it is a bunch of broads taking care of that man for the rest of his life.
Oh, good Lord. Okay. Anyways. Debtors' agreement to dismissal with 2-year barring to refiling. Counsel for the UST has conferred with debtors regarding the relief requested herein, i.e. dismissal with a 2-year bar to refiling. Debtors stated that they will agree to that relief, but dispute any factual assertions in the UST supplemental response. So, I mean, they don't want to, agree that they did this in bad faith. They don't want to agree that they misrepresented things or didn't file things, you know what I mean, they were supposed to. Of course, they don't want to agree to that, but that is what happened. So,
right.
Yeah.
Yeah. That's clearly what happened. And it was pretty well laid out here, in my opinion, allegedly.
Yeah. All right. Let's see. We're almost done with this document. Wherefore the UST respectfully requests the court dismiss the Chapter 11 case under this section with prejudice to filing of any bankruptcy petition by either debtor for 2 years from entry and grant such or other relief as is just and proper. So I don't know the likelihood of, like I said, any criminal charges being brought. I know this, it sounds like nothing would come of like a civil process. So I guess I agree with that. I do hope that they don't just get away with it. I guess technically though, like having their house foreclosed upon is not really getting away with it. You know what I mean? It's just like, but at the same time, it's like, I hate that they keep abusing the systems like this.
No, I know. And I think that they've really, I think it's come to a head at this point. If nothing comes out of it at this point, I don't know what to do about it. But like they, if you compare this to her stipulated agreement with Laura, which is, a lot different. There's like she lays out charges in this pretty well. This is not Laura's dismissal. This is very different. And I think if I were them, I'd be concerned, but
was it the same trustee in Laura's case, or was it a different one?
It was, okay. So the Jennifer Giammo was in both Laura's case and this case,
right?
But there was, in a chapter 11, there's no like lower level trustee. So, so no, to answer your question, no, because they didn't have a trustee technically in this case. They have the US trustee overseeing it, but not like which one was it? Eric Haley, I think was Laura's bankruptcy.
And you remember that.
Well, because Edward Manny was Ron and Jan's first chapter 13 trustee.
Dude, I don't know how you remember all this stuff.
I mean, it's just my part of the world that I pay attention to this stuff. Don't ask me about deadlines in Mike's case. I have no idea.
All I remember is Frosted Flakes, so I don't know the names.
Frosted Flakes? I love the way she said Frosted Flakes. I love the way Flakes. The way she said Frosted Flakes was gorgeous. I just loved it. And also the that was my favorite part.
Oh my god. That was so hard to listen to.
It was hard. It was beautiful. It was everything. Like, it was all the things, right? It was uncomfortable. It was like, oh my God, Jan, just answer her question, please.
Yeah, I get really bad secondhand embarrassment. Like when I listen to stuff like that, it's like, even if I don't like the people and I'm like, yes, I want to see you go down for your crimes. It's like, I get such bad cringe, secondhand cringe, that I'm just kind of like, oh shit.
So do I, seriously. Like, I often don't, like, I maybe watch this one twice, but I don't in general, because
You watched it twice?
Yeah, because I had to like go through it, right, myself, but like, I just can't. Like, I was there in live, and then I watched it, so twice, and I don't know. It was awful.
Let me see, run through these real quick. Kirsty Jones, 629, thank you for the 10 jewels. Oh, and thank you again for the 10 jewels. I appreciate that. And Wendy Michelle, hey, how's it going, Wendy? Thank you for the $2. Just kick them out of the house. You do it. No, I'm just kidding. Thank you, Wendy. I appreciate that. I mean, they are probably going to get kicked out of the house. I don't know where they're going to go. So, and I don't know where Laura's going to go. She can't leave the state of Arizona. She's got a trial coming up, assuming that she doesn't take a plea deal, which I don't think she will. Right. That's coming up pretty soon too, isn't it?
There's a conference at the end of August, but the new trial date, I think the new scheduling date is in October. So then that would make us for November, I think.
Yeah, I just I'm assuming that she won't take the plea by the deadline, which is this month again, and then that's where we're going to be headed. But I don't know. She's got that attorney that she's not going to be able to pay for a whole trial. Trials are expensive. There's no way she can pay that attorney for a trial. So she's probably going to end up with a public defender and go through the whole thing. You know what I mean? And then if she goes with a public defender, I'm assuming they will give her another extension. So,
well, and that's the other thing about Ron and Jan in this dismissal that is frustrating, is that they'll be free to keep paying her attorney then. Right. Which is frustrating, but I mean, whatever. As long as I understand not prejudicing their creditors. Their creditors deserve to be able to try to collect against them. Yeah. Well, so how would that work if they file lawsuits against them and they get a judgment? It would take a while, first of all, and then second, would they be able to then have that court order that part of their monthly payments comes out and goes to the people they're in debt to, or no? They could. Okay, I didn't know if that would work with the pension. So yeah, so like I said, it's weird with pension, but I think the pension is not exempt. It's possible it is, but the Social Security for sure, like for the average person, is exempt, right? They can't garnish Social Security. Right. What they can do is file levies on your bank accounts, and your income tax returns, for your state income tax returns, if you file them, and other things that. But they can also make the argument that since you commingled the money, it's not exempt anymore. So it'll be interesting to see financially how it plays out over time. What I don't think that they count on is that so what'll happen with a lot of this debt is it'll get sold off. Ari's playing, so you can hear her squeaking. It'll get sold off to like those like hedge fund companies or whatever that do the, you know, like the pump and duck. You know, they just
I know what you mean.
Yeah, and they'll those people are aggressive. So
well, maybe while they're in limbo before that happens, they'll start investing in crypto and strike it big.
Oh my God. Oh my God. Don't give them any ideas. Oh my God.
Cases We Follow says, what about their property taxes? Have they been paid? Man, these people aren't paying any taxes, I'm pretty sure. But
the lender is paying the lender is paying taxes right now. Yeah. I don't think they're paying them on time, so to speak, but they're paying them. Like the Owens are not paying them.
Right.
The lender's paying them out of a negative escrow account.
Right.
Wow.
Michelle R2222, thank you for the 10 jewels. Appreciate that. Thank you very much. Well, I guess that's all I got for now, guys. Then, if that's the filing, I guess they're hearing in like 3 days. Thursday. Yep. All right. Cool. Yeah. Well, don't forget to follow Tiff's channel. The mods put a link to her channel in the chat there. And if you want to hear more about that, I'm sure she'll be going over it there. I don't know when she's going to do that. Are you going to do that tonight? Probably not tonight. I don't know. Okay. Maybe. We'll see. Okay. We'll see. So that's me. That's what you get with me. I don't know. We'll see. No, it's all good, dude. And then also, guys, if you want to, like I said, if you miss notifications when I go live on YouTube and you want to sign up for free notifications on the Patreon, I pinned the link to that in the chat there. I will also put it in the links in the comments after this live ends. So, all right. Thank you, everybody. And thank you to Tiff. I will talk to you guys probably soon, I'm sure. All right. Thanks, everyone. Bye.